So the same four irregularities, the Gram Panchayat penalized me, I'm sorry, the concerned authorities penalized me twice earlier, which was set aside by the High Court, once themselves and once by the High Court. Now, the first occasion for the same four irregularities, they punished me on 26/11/2020, and the valuation of penalty was 1,06,000. This was in 2020. That was set aside by this honorable court. The second time they penalized me on 6/12/2021 at a value of rupees 13,85,672, surprisingly for the same four irregularities. That was set aside by their own commissioner on account of jurisdiction. Now for the third time, the same 13,85,672 have been penalized for once again. And there are two grounds which we raised before. This time, the jurisdiction seems to be correct. The CEO Jila Panchayat has done it. But what he's done is, for the purpose of a factual inquiry, he first sends the matter to the CEO Janpat Panchayat. Janpat Panchayat returns a report saying there are no irregularities. That's part of the impugned order. For no reason, he divests his opinion from that Janpat Panchayat and he seeks 2 or 3 more opinions. In those 2 or 3 more opinions also, there is absolutely nothing which quantifies or says that those 4 irregularities are met in any manner. And the same amount, without any application of mine, 13,85,672 imposes on me again. I am the secretary and the sarpanch. And if my lords will see the impugned order, that is P7. Before that, if my lords may just have P1 for a moment, I'll just show my lords that the same 4 irregularities are from day 1. Has my lords gotten P1, my lords?
So there is no bar as such because it was not decided on merits.
No, I'm not saying there's a bar, but yes. I'm saying the first inquiry for the same irregularities you penalize me.
Yes.
But for 1 lakh. And this third inquiry, even if you omit the second one because that went on jurisdiction,
yes.
Even if you see the third inquiry, same 4 irregularities, one equivalent officer as to you, that is an IAS officer, CEO, Janpat Panchayat.
For same period.
For same irregularities, man. That's what I want to show, Malad.
Yes.
And for 5 years, they're conducting the same inquiry again and again. Absolute non-application of.
You are raising Article 20?
Beg your pardon?
Grounds of Article 20?
Article 21, Malad.
21.
And yes.
Yes, state.
You will seek instruction.
Execution of it is ongoing. If that may be just state, Malad, till the next state.
Petitioner has filed this petition under Article 226 of the Constitution of India, raising a ground that he cannot be vexed twice for the same cause. पहले वाले में क्या हुआ?
पहला वाला was also set aside by the Honorable High Court.
Set aside. So that, then no question of vexed twice.
I'm not saying that. My only submission is, Manoj, it's a case of non-application of mine. Same 4 irregularities, you penalize me 1 lakh. Now you penalize me for 13 lakhs.
That has been set aside. आप वो तो भूल जाइए आप.
Fair enough. This second inquiry.
Now you cannot rely on 1 lakh. It has been set aside. Now they have done fresh.
Be that as it.
Yes.
Now, whereas in this third and the ultimate report also which they claim against me, the CEO Janpat Panchayat gives them a report saying there are no irregularities found. That is why I was showing Malos P7, the impugned order, without assigning any reasons. The last paragraph is just a copy.
Annexure P?
P7. If my lords will just have. These are the 4 irregularities, my lords, on page 36. The report of the Janpat Panchayat, my lords, is on page 39. This is the Jila Panchayat is conducting the inquiry. For fact finding, he sends it to the CEO, Janpat Panchayat. His findings are on page 39 on the 4 irregularities.
This is the detailed order.
No, I'll just point out for mine.
Yes.
It's all copy pasting. It's nothing is detailed. If my lords will see page 39, my lords.
Yes.
There are 4 points which my lords will see over here, right in the middle. This is the report of the CEO Janpat Panchayat.
Yes.
To the inquiry. He says for irregularity number 1, which was that there was some tin number or something not mentioned, and trade has been done with that. He says Gram Panchayat such and such आरोपित निर्माण कार्यों से संबंधित अभिलेख पाए गए एवं हाजरा ट्रेडर्स लखनदौन का टिन नंबर जीएसटी नंबर का जीवत पंजीयन पाया गया. The allegation was that there was no GST number or tin number. Second is दर्ज समस्त निर्माण कार्यों का प्राकलन पाए गए. They said there was no recommendation. It was done without that. That is also there. दर्ज आरोपित भुगतान किए जाना पाया गया. Fourth is दर्ज भुगतान का मूल्यांकन एवं भुगतान से संबंधित बिल वाउचर रोकड़ बही एवं एवरीथिंग समय पे पाया.
Article 226 of the Constitution of India challenging order dated. This is dated
23/9/24.
23/9/24. It is submitted that order has been passed mechanically without application of mind and no reasoning is given for imposing penalty. Notices to respondent PF 7 days, returnable in 4 weeks. Order dated so and so shall remain stayed till next date of hearing.
This matter pertains again to that food control order. My lords has already settled this issue. And on the last day, the state was given an opportunity to seek any instructions if they like.
Yes, state.
Instructions are yet to be clear.
The judgment which I would press is my lord's own order.
Counsel appearing for petitioner relied upon order dated 24/9/24, passed in MCRC number so and so. It is submitted that opinion of collector is not obtained. Full stop. Notices, order dated.
FIR and charge sheet, the ST number is mentioned in the state.
Till next date of hearing, no coercive action be taken against petitioner.
No coercive was on the last day, that the proceedings will be stayed.
So what you want now?
There is no coercive, the trial will
State, file your reply. Government advocate is granted 4 weeks time to file reply.
The ST number is in my stay application. Proceedings could be kept in
No,
abeyance.
no, not required.
As it pleases.
आपको protection तो है, no coercive action.
As it pleases.